Good afternoon, Mr. Schmidt. Mr. Schmidt, can you say something for me so I can make sure I don't have any technical issues? Well, I show to be unmuted. Maybe it's on.
I can hear you, Judge, if you can hear me.
You can hear me?
Yes, sir.
Y'all cannot? Guessing there's speakers not on. I think it's on their end for sure. Fabio is not over there with tapering him today, so that may be it. You don't have her. Maybe Fabio will have to find out about that when he gets back.
Could be, yeah.
All right, Mr. Schmidt, can you see and hear me now?
I can. We're having audio difficulties on the big screen. This is on my phone, but Judge, I have Seth Adkins here. CR 25-279 and 22-368.
All right, yes, I think we're set on the state's motion to revoke and also pretrial. Go ahead.
That's correct, Judge. Normally I wouldn't have been here on Thursday. I'm not sure how Mr. Adkins got set today, so I wasn't prepared. But for announcement's sake, I thought we had a setting on him on March 31st. Because he's got the MTA on CR 22-368, so I presumed it was on your next contested docket.
You wanna move it over to the 31st?
Could we move it over to 31st and carry that pretrial as well? I don't think that I have any contested at this point, but I need to double check.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Atkins for March 31st on the motion to revoke and also on the pretrial. Yeah, Mr. Schmidt, it would probably just oversight on the court's.
Yes, sir. Let's see it. Have a good day. You got it. Hey, David. Dixon.
Just a moment, this is gonna be a plea, is that correct?
It is a plea, Judge. You should have the paperwork in your queue.
Looks like we're gonna be resolving SC 2544 today and your 1245. Is that still pending in the county court of law?
It is, Judge, and I did that intentionally. I have not transferred it up. I have a hard copies, the original hard copy signed by the state that I'm going to hand deliver to Judge Winters after this is over today. But it made it into that plea packet, so we went ahead and signed it again. But I anticipated taking a hard copy original to Judge Winters.
Okay, the only complication that's gonna cause is I have to sign the order in this e-file packet, otherwise it will not let me process the plea agreement without a signature. So I think I'm gonna go ahead and sign it today, but I want you to
Yes,
take
sir.
Judge Winters. I don't think having two 1245s is going to hurt, so, but
I agree.
there is gonna be a signed one, but since he still has it in his court, has jurisdiction, I'd like for him to sign.
Yes, sir.
All right. Mr. Dixon, sir, if you'll raise your right hand, I'm gonna place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, Connelly. Your name is David Paul Dixon, is that correct?
Yes, sir.
And Mr. Dixon, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about any of the paperwork that you've read and signed today?
No, sir.
All right, Mr. Dixon, you are charged in cause number CR 26-9 with a third-degree felony offense of possession of a controlled substance in penalty group 1 or 1B, greater than 1 gram, less than 4 grams. The range of punishment for a third-degree felony in Texas is confinement in prison for not less than 2 years or more than 10 years, and a fine, if imposed, not to exceed $10,000. I see that there is a plea agreement in this case. Upon you pleading guilty, the state's recommending that your punishment be assessed at 3 years confinement in prison, a $1,000 fine, restitution of $180, and the state is agreeing to consider a filed FC 25-44 case in the county court of law to dispose of it. You would also be assessed court cost of $290 and reimbursement fees of $20. Mr. Schmidt, how much time credit would Mr. Dixon be entitled to?
Your Honor, I show 289 days.
289 days?
If defense is in agreement.
Correct.
Is that correct, Mr. Schmidt? 289 days credit for Mr. Dixon?
Yes, sir.
All right. All right, then, Mr. Schmidt, do you believe your client to be competent to enter into this agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after having been explained to him his legal rights?
Yes, I do.
All right, Mr. Dixon, at this time, I would ask you, how do you plead to possession of a controlled substance in penalty group 1 or 1B greater than 1 gram, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Dixon, has anyone threatened you, forced you, or pressured you to plead guilty to this crime?
No, sir.
All right, then the court will accept the defendant's plea of guilty at this time. Mr. Schmidt, any objections to the evidence being admitted?
No objection.
All right, the court takes judicial notice of the defendant's judicial confession, and the evidence is admitted. Is there anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then the court's going to review the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement between the state and the defense. Court hereby convicts the defendant, David Paul Dixon Jr., of possession of a controlled substance, a third-degree felony, assesses punishment at 3 years confinement in the Texas Department of Criminal Justice. Court orders him to pay a $1,000 fine, restitution of $180, court cost of $290, and reimbursement fees of $20. Court also finds that FC 25-44 is taken into consideration with the defendant's plea in this case, and the court awards the defendant 289 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Dixon, once you are released from prison, if you've not paid off all of your financial obligations, then you are to report to the courthouse and make a payment arrangement and a payment plan. Failure to do so could result in an arrest warrant. Do you understand? Mr. Schmidt, can you hear me?
I can hear you, yes. There's a
Okay.
lag.
It's okay. Did Mr. Dixon hear me say that he needs to report to the courthouse to pay his fines?
Yes, sir.
Okay. All right. So, Mr. Dixon, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the judgment. I'm going to have you be fingerprinted. Good luck to you, sir.
Thank you. And Judge, I don't know if you can still hear me, but we've got video in here, but no audio. So they're trying to figure out what the deal is with that.
Okay. Yes. Let's take a minute and y'all can work on that. I'm going to sign these plea papers and then we'll give y'all some time to see if y'all can figure it out.
Yes, sir.
Did you? When I went to just Zoom, it wouldn't go. It's making me download the Zoom workplace. It's going slow.
Oh, well, yeah, it is going super slow. I already had the app, so that's what I just used.
I need to go outside.
Yeah. It's always in boundary side.
You're saying the purchase the phone with that? Is that the X Fold 7
Yeah, Z fold.
or Z Fold?
Yeah. I like it.
It seems so interesting.
Yeah. You don't have Zoom on your phone, do you?
Oh, actually.
And maybe, I mean, what I just did was just log in from here to do the plea. Otherwise, it'll be, they may not be able to get this other thing fixed. Always something.
Is it the volume or the audio?
Do you have FaceTime?
No, I have an Android. Yes, if we put the unmute.
Yeah.
Okay, we clicked unmute.
We've been to the settings and,
I have no clue. I just called you. I have no clue.
anyway, we're on my phone, so we're gonna switch over to it.
So.
It-
Yes.
Yes, and it's the speakerphone box, little round box that's not working. Okay.
Okay, whoever's next. I'm sorry.
Mr. Ogletree.
This thing's not working.
That's not working.
Can you?
All right, Mr. Casillas, you're here with Mr. Joshua Jones, correct?
Yes, Your Honor.
All right, I'm gonna go ahead and call.
Can
the
you hear me?
case. Yes, I can hear you. There's a little bit of a lag, so we just have to accommodate that. This is cause number CR 25-206, 207, and 208, State of Texas versus Joshua Caleb Jones. And I believe that we're set for docket call today. Any announcements, Mr. Casillas?
Your Honor, the prosecutor was looking into whether or not he could get some information that would affect the deadly weapon allegation. I'm not certain he found that information or not.
That's correct, Judge. We were unable to make a determination on that, and I've been trying to reach out to Mr. Casillas to discuss an offer so that he would be aware and he could discuss it with his client. I even tried before the lunch hour to reach back out to him, and I did not hear back. So if we could have just a few minutes, maybe to discuss that, I could at least share that information with him, and we could recall the case.
Yes, sir. Okay. All right. So Mr. Casillas, Mr. Jones, you go have a seat. Mr. Casillas, you and Mr. Hernandez talk about it, and then let me know when you are ready to make another announcement. So Mr. Jones, you can go have a seat. Yeah.
I'm doing.
All right, Mr. Manny, who you ready on?
Judge, if we can start with Mr. Spencer.
Court calls CR 25-25 State versus Clayton James Spencer. Mr. Spencer is verified in custody in the Texas Department of Criminal Justice in the Gurney unit. Any announcements?
Judge, not at this time.
Your Honor, I apologize, if I, missed getting a request for a bench warrant, but state would request that at this time.
All right, court sets Mr. Spencer then for April 23rd. The court will issue a bench warrant. Thanks, Mr. Manny.
Judge, next ready on Mr. Baird. Judge, I've just been informed that Mr. Baird hasn't been brought in yet. We can do Mr. Estrada.
Matthew Estrada, CR 20-40. Will this be a plea today?
Yes, Judge.
All right, Mr. Estrada, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony that you give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. All right, Mr. Estrada, you appeared before the court previously on April 6th of 2020. You pled guilty to the offense of assault of a family or household member with a previous conviction. The court assessed your punishment on that day at 6 years confinement in prison and a $1,500 fine, but the court then suspended your sentence because of a plea agreement and placed you on community supervision for 4 years.
Yes, sir.
And your community supervision was also extended for an additional 1 year with an expiration date of April 5th of 2025. On May 16th of 2024, the state filed a motion to revoke your community supervision, and they have alleged 10 allegations of violations. Have you had enough time to review that motion to revoke and the allegations with your attorney, Mr. Jonathan Manning?
Yes, sir, I have.
Are you pleased with Mr. Manning as your attorney and the work that he's done?
Yes, sir, I am.
Do you have any questions about anything before we proceed further?
No, sir.
Mr. Manning, do you believe your client to be competent to enter into a plea agreement? If so, is he doing it intentionally, knowingly, and voluntarily after having been explained his legal rights?
Judge, he is competent. I believe he's entering into the plea intentionally, knowingly, and voluntarily, and he's waiving his rights to a hearing in order to go forward with this plea.
Is he waiving the formal reading of the state's motion and intending to plead true to all counts?
Yes, Judge, we've already reviewed the state's motion, and he does intend to plead true to all counts.
All right, very well. All right, Mr. Estrada, at this time, I would ask you, how do you plead to counts 1 through 10 in the state's motion to revoke? Are those counts true or not true?
True.
Are you pleading true to those counts because, in fact, each thing that is alleged is true, that you either committed that or failed to comply with the court's orders?
Yes, sir.
All right.
True.
All right. And has anyone threatened you, forced you, or pressured you to plead true to any counts?
No, sir.
All right, the court does accept the defendant's plea of true to all counts contained in the state's motion. Mr. Manning, any objection to the evidence being admitted?
No objection as offered.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest in closed, Judge.
All right, the court, having received the testimony, the court hereby finds that the defendant, Matthew Estrada, has violated the terms and conditions of his community supervision. The court finds counts 1 through 10 to be true. The court hereby follows the plea agreement. In this case, the court revokes the community supervision of Mr. Estrada, assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice, and orders him to pay the balance of his financial obligations, including a $1,500 fine, $190 court cost, $160 in reimbursement fees. Mr. Manning, how much credit time is Mr. Estrada entitled to?
Judge, we've calculated and agreed that he is entitled to 382 days credit. We're taking a shot.
382.
Yes,
All right.
Judge.
Court hereby awards the defendant 382 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Estrada, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from prison, if you've not paid off your financial obligations, you're ordered to report to the courthouse to make arrangements to do so. Do you understand?
Yes, sir. And Judge, I have provided him with the information for the court collections office. It is on his bill of cost sheet.
Thank you, Mr. Manning. All right, Mr. Estrada, step over to be fingerprinted.
All right. Judge, I think we may have audio.
I'm starting to hear a double loop, so you probably have Ms. Abraham just mute her phone first and let's test it before she exits. Can you still hear me? No. Then there's no audio.
Judge, can you hear us?
I can hear some, but it's not clear.
You're getting the microphone.
Judge, it appears we're getting a microphone from, we've got a new device and we're getting a microphone, but not the speaker function.
This Abraham, need you to mute. Okay, say that again, Mr. Manning. I had to mute Ms. Abraham. Her phone was creating a sound loop. Can you hear it all?
Judge, it appears that we're just getting the microphone function.
We're still not getting this audio here.
Judge, can you say something?
Test, test. Microphone test.
All I can do is hear him out of here.
Yeah, Judge, we're not getting you on this side.
This says output device. For whatever reason, I think it needs to be restarted because the driver's in there.
He wants to restart it or just stay on my phone.
Judge, would you like for us to restart the computer and possibly fix the connection? Or would you like for us to continue on Ms. Taberham's phone?
Let's try, can you hear me at all?
Yes, Your Honor.
Restart. Let's try to restart.
Okay.
Yeah.
Try to restart.
So do we have the Zoom link and all that? Is there a password on this computer?
Yes. Yeah,
Oh, yeah, we know.
We know. Okay.
Yeah. Yeah, Your Honor.
I heard you. Did you hear me?
Why are they going to the phone instead of that?
Test, test.
I'm just turning.
I can hear you.
Judge?
I can hear you. Can you hear me?
We're
Yeah.
all hearing.
I can hear you. Good.
Oh,
Judge, I can hear them just fine as well.
Judge, we got audio on our side now.
Excellent. Excellent. Good. It was worth the reset.
Thank you, Mr. Bailey.
All right. Who are you ready on now?
Judge, let me see who they have in here right now. Judge, if we can go with Mr. Johnson.
Ryan Parker Johnson, CR 24-194. Mr. Johnson's set on a motion to revoke.
Yes, Judge, I've recently been appointed on his case, and we received a motion. I have not had opportunity to go over that with Mr. Johnson. I request a reset on this case for us to prepare. If you want to set some evidentiary docket, that'd be fine.
All right, court sets Mr. Johnson on April 30th at 1:30.
Yeah. Good. Yeah, you're good to go.
Who's next?
Judge, next ready on Mr. Lacader, Cody Lacader.
Cody Ryan Lassiter, CR 25-209. Mr. Lassiter is set for pretrial.
And Your Honor, state, after conferring with our office, we've decided to relinquish this case for federal prosecution or federal investigation. That referral has been made, so state moves to dismiss, and I'll get a paper motion to you.
Okay. So you made the referral, but they've not accepted the case?
Correct, Your Honor.
And so if they decline the case, the state indicates that it's not going to be prosecuting him in that matter either?
Right, Your Honor. At this point, we're referring it to the feds, the ball's in their court, see what they want to do with it.
Right, but I'm saying if they reject it, you want me to dismiss it today, he'll be released today.
Yes, sir.
Okay. All right, court, having entertained the state's motion to dismiss, court hereby dismisses the case. And I'll get that order signed and you'll be released.
Yes, sir. No problem.
Who's next?
Judge, next ready on Mr. Let's see if he's in here. Hold on one second. Mr. Larry McCain.
Larry Dean McCain, CR 25-280 for pretrial. Go ahead.
Yes, Judge. In speaking with the state, we are continuing negotiations on this, and I am still looking for some video that I think would be dispositive in this case. If we could have additional reset on pretrial, my hope is that I have something. If I have something, it'll be dispositive. If not, we'll be able to move on to our docket call setting.
Is this video that the state has?
No, Judge. It was a third-party video from the campgrounds where Mr. McCain was staying, where the incident happened.
Okay. But can I move it to docket call? You're not saying you need pretrial for your own video, right? You're indicating that we can move it over to docket call.
Yeah, that's fine, Judge. Yeah, if you want to, we can move it to docket call.
All right, court sets Mr. McCain then for docket call on April 2nd. Does that give you enough time, Mr. Manning?
Yes, Judge. I've reached out to the facility multiple times, so I'm just going to drive out there and see if I can track it down.
All right, April 2nd, 1:30.
Thank you, Judge. We're good. There you go.
Who's next?
Judge, ready on Mr. Clint Mills.
Clint Wayne Mills, CR 25-235. Mr. Mills is set for Dr. 12.
Yes, Judge. Mr. Mills and I have discussed this state's offer, and he wishes to proceed to jury selection.
And what is the state's offer that's being rejected?
Judge, I'm sorry, I didn't write it down. I believe it was, if I may have just a moment. It was for a significant amount of pen time.
Your Honor, last email I show is for 25 TDCJ.
25 years?
Yes,
Yes, sir.
Judge.
All right. And what's the range of punishment in this? Is it a true F1 or is it a enhanced?
I believe it's going to be enhanced, Your Honor, habitual.
Okay. All right. Court finds that the state has made an offer. The defense has rejected it. Court will not entertain plea agreements for Mr. Mills after today. Court hereby places Mr. Mills on the court's jury selection docket. We'll begin that Monday, March 16th. And he'll remain on the court's rolling trial docket each month until his case is reached for trial. Who's next?
Judge, next I'm ready on Mr. Peck.
Richard Charles Peck Jr. Mr. Peck is set for pretrial.
Yes, Judge. So an issue came to my attention recently. I've contacted the DA's office. I believe it was yesterday, so I haven't got a response from them yet. But I believe that it may lead to an additional need for additional pretrial on this case regarding the officer involved in the offense.
Any objection from the state?
No objection, Your Honor.
All right, court will grant Mr. Peck an additional pretrial hearing April 2nd at 1:30.
Right there. So, yeah. Fired. Pardon me, Judge, I'm just looking to see who they brought up and who I have ready. Judge, I believe I'm ready on Michael Powell.
Michael Ray Powell Jr., CR 25-272-282. Mr. Powell set for docket call.
Yes, Judge, if I may have just a moment.
Yes.
Judge, Mr. Powell has rejected the state's offer of 20 years TDCJ and requests to be set on the jury trial docket.
All right, court finds that the defendant, having rejected the state's offer, places the defendant on the jury trial docket March 16th, where he'll remain until his case is tried each month thereafter. Who's next?
Judge, I believe that is all that I have in here currently that are ready at this time.
Okay. Court is back on record in cause numbers CR 25-206, 207, 208, State versus Joshua Jones. Mr. Casillas, did you and Mr. Hernandez have a chance to confer?
Yes, Your Honor, we had a phone call together. He has relayed to me the terms of the offer. I would simply ask the court's indulgence for a short continuance so I could discuss with my client and his family members the different ramifications regarding what I think as an offer is fair.
Okay. All right, then what I'll do is I'll grant you a final docket call on April 2nd. If you have your schedule with you, you're welcome to check it. Because if that date is not going to work, I'd rather reset you to a date that's going to work than have to have a motion for continuance.
Thank you, Your Honor. Let me check here. April 2nd should work fine, Your Honor.
All right, great. Court sets Mr. Jones in for final docket call April 2nd. Final docket call means, Mr. Casillas, that he either is going to announce that he's accepting a plea agreement, or he's requesting a jury trial, or the state's dismissing the case. Something dispositive.
Thank you, Your Honor.
You're welcome.
And Your Honor, I also have a Corey Prox.
Yes. All right, thank you, Mr. Jones. You can step back. Corey Demont Prox, CR 25-257. Mr. Prox is set for pretrial.
That is my understanding, Your Honor, yes.
Any announcements? Do you have all your discovery? Any contested pretrial issues?
At this moment, no contested pretrial issues, but Your Honor, we have been given discovery. We believe that there's a surveillance video from the field where the sporting event was going on, where the alleged offense occurred, and we didn't see that in our discovery. Mr. Hernandez may be able to clarify whether they think such a surveillance video actually exists or not.
Your Honor, and I'm sorry, Mr. Casillas, I've actually been communicating mostly on this one. I know that from the email chain between Miss Abney and I'm sorry, I forgot your partner's name. I wasn't clear what the video was that you're looking for. Now that I know it's a surveillance video, I'll take a look specifically for that, and I'll get back with you guys. I know Miss Abney has been working on making sure that all the videos that we have are uploaded and available. If there is surveillance video, we'll be sure to get that and get it over to you as soon as we can.
Thank you very much. So, Your Honor, we would ask for a short continuance on this one as well.
All right, court will grant your request and sets Mr. Prox in for pretrial on April 2nd.
Thank you, Your Honor.
You're welcome.
May we be excused.
Yes, sir. Thank you.
There is just a liner on.
I told him that I would let him know whenever when we got ready. So let me tell him right now.
Judge, and also I forgot, I have one plea that was ready that we did not already do, Mr. Richardson.
I'm sorry, say that again.
We have one other plea that's ready, Patrick Richardson.
All right, go ahead and bring Mr. Richardson up and I'll get Mr. Wiley. All right, Mr. Richardson, if you will raise your right hand, place you under oath. This is cause number CR 25-186, State of Texas versus Patrick Lee Richardson. Mr. Richardson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, sir.
Thanks, sir. You can lower your hand. Just make sure you speak up loudly and clearly so I can hear you on this end, okay? All right, Mr. Richardson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney?
Yes, sir.
Do you understand everything that you've read and signed that's in your plea agreement?
Yes, sir.
Do you have any questions about anything before we proceed further?
No, sir.
Very well. Mr. Manning, do you believe your client to be competent? If so, that he understands his legal rights and is entering into this agreement intentionally, knowingly, and voluntarily?
Judge, I believe he is competent. I believe he's entering this plea intentionally, knowingly, voluntarily. I understand, and he understands that he's waiving certain rights in order to take this plea.
And Mr. Richardson, I don't know if I asked you, have you ever been diagnosed with any type of mental condition?
No, sir.
Okay, very well. All right, Mr. Richardson, I see that you are charged with a third-degree felony offense of continuous violence against the family, a third-degree felony that carries a range of punishment of not more than 2 years, not less than 2 years or more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement is that you would be pleading guilty. The state would be recommending 3 years in prison, along with fine of $1,500, court cost of $290, reimbursement fees of $20. And it appears that the state would be rejecting an unfiled assault case. Mr. Richardson, is that your understanding of the plea agreement?
Yes, sir.
Mr. Manning, how much credit time would he be entitled to on this plea?
Judge, we've agreed that he has 253 days credit time.
All right, very well. All right, Mr. Richardson, then, how do you plead to continuous violence against the family?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
No objection as offered.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with victim contact. The victim impact statement was provided and not returned.
Thank you, Mr. Hartwell. Anything further from the defense?
Rest of those, Judge.
All right, court is going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement and recommendation. Court hereby convicts Patrick Lee Richardson of continuous violence against the family. Assesses punishment at 3 years confinement in prison. Orders him to pay a $1,500 fine plus court costs of $290 and reimbursement fees of $20. Further, these court finds that the state is agreeing to reject, and the court does take into consideration DA 2025-635, assault of a family or household member by impeding breath or circulation. Court hereby awards Mr. Richardson 253 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Richardson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. When you're released from prison, if you've not paid off everything you owe, you're ordered to report to the courthouse and make arrangements to do so. If you fail to do that, an arrest warrant could issue for you. Do you understand?
Yes, sir.
All right. Step over with the deputy to be fingerprinted. Who's going to be next, Mr. Manning?
Judge, we have just a quick reset on Mr. Haidider, and then I'll have some plea paperwork to work on.
Court calls CR 25-205, State versus Demarcus Haidider for docket call. Go ahead, Mr. Manning.
Yes, Judge. Defense rejects the offer made by the state and requests to be set for jury selection.
And what is the offer that's being rejected?
Judge, it was for time. I don't recall what time, but it was never a consideration for Mr. Hyder.
State, are you aware what the offer is?
Your Honor, I believe it was for 25, but let me, give me just a moment that I can. confirm. Yes, Your Honor, 25 years TDCJ.
All right, thank you. All right, court finding that the defendant has rejected the state's offer. The court sets the defendant for jury selection on March 16th. And Mr. Hyder will stay on the court's trial docket until his case is reached for trial.
And Your Honor, since this is a child victim, would the court entertain a special setting at some point?
Yes, I will consider that at the close of the docket today.
Thank you, Your Honor.
Thank you, sir. All right, Ms. Abraham, if you'll go ahead and bring up Mr. Weiner's client, Mr. Jordan, I'm going to bring him in.
Yeah, let me see.
All right, good afternoon, Mr. Weiner. Can you see and hear me okay?
Yes, Your Honor. Thank you.
You're welcome. All right, this is cause number CR 25-80, State of Texas versus Bobby Eugene Jordan. I believe we're set on two issues today. Docket call for the court, and then I believe the defendant's motion to terminate attorney, and then Mr. Weiner, your motion to withdraw as counsel. So let's take up the docket call first. Has an offer been extended that the defendant has rejected?
There was an offer that my client did not want to accept. That offer was withdrawn after what occurred at the last setting, and we have not gotten a new offer. So at this point, we don't have an offer, and so there's nothing for us to entertain at this point, Judge.
All right. And then Mr. Weiner, I'll go ahead and let you take up your motion to withdraw.
Yes, Your Honor. I obviously received the filings from my client that he wanted to terminate me and be replaced by court-appointed counsel. And when I received that, I went ahead and filed a motion to withdraw. And I listed numerous reasons, specifically breakdown in the relationship between myself and Mr. Jordan, his failure to comply with his financial obligations that were agreed upon when he hired me. And then there's some additional information that he has given me, that I don't want to get into privileged information, but it's potentially made me a witness at a potential case. And so for all those reasons, Judge, and at his request as well, I'd ask that you would let me withdraw off the case.
And Mr. Jordan, I'm going to let you be heard, but I want you to limit your statements to the matters of motion to withdraw and not anything about your case that could be used against you by the prosecutors. You understand?
Yes,
so
sir.
You're wanting the court to allow Mr. Weiner to withdraw, and you're asking the court to appoint you a court-appointed attorney?
Yes, sir.
And why are you doing that?
Because I'm out of funds. I don't have no money to pay for an attorney at this time.
So you agree that you've not paid him to do the job that you hired him to do?
Yes, for lack of funds, I'm not working, not making no money because I'm in jail, I'm incarcerated.
And we know why you're in jail, don't we? We're not debating that, are we?
Yes, sir.
Okay.
Yeah, no, well, yeah, I understand why I'm in jail, yes.
Okay. All right. Then the court will, Mr. Weiner, the court will grant your motion to withdraw as counsel. And the court will consider Mr. Jordan's request. And did you submit an affidavit of indigency through the sheriff's office? Did?
He did, Judge.
Okay. All right. Then the court will, I will consider that. And if you qualify, then the court will appoint you an attorney. If you do not qualify, then I'll have another hearing and tell you so. Okay. So what I'm going to do is I'm going to reset Mr. Jordan's case. Or actually, I'm going to set Mr. Jordan for trial. And we're going to set him for March 16th. And just put him on the trial docket. And then if you get a court-appointed attorney, then I'll let the court-appointed attorney determine whether we need to go backwards. Otherwise, we'll just go forwards on a trial.
Yes, Your Honor.
All right, thank you, Mr. Weiner.
Thank you. And Bobby, no hard feelings, obviously. And Judge, if you don't mind, could you have your court coordinator let me know if he gets appointed a lawyer so I can help get them up to speed as quickly as possible and make sure they have everything they need for my file?
Yes, sir, we will do that. I appreciate that offer.
Thank you so much, Judge. May I be excused?
You're welcome. Yes, sir.
Thank you. Bye.
Done?
Yep, you're done.
Your Honor, I think Mr. Manning is going over some paperwork.
Okay, all right, court will stand in recess until Mr. Manning is ready for this, please. Mr. Manning, who are you ready on?
Judge, this is Miss Connelly. She was added to the docket with a plea to an information that was filed, I believe, yesterday.
All right, this is cause number CR 26-21, State versus Lindsay Marie Connelly. And we're gonna do the plea today. Is that correct, Mr. Manning?
That's correct, Judge.
All right, Ms. Connelly, if you will raise your right hand, I'm gonna place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Give me just one moment. I'm gonna pull up your paperwork. Manning, you said this is gonna be a waiver of indictment and plea to an information.
That's correct, Judge.
All right, Ms. Connelly, your name is Lindsay Marie Connelly, is that correct?
Yes.
And Ms. Connelly, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
ADHD, bipolar, depression, PTSD.
Are you on medication or treatment for those?
Yes.
Do you feel like your disorders in any way are interfering with your ability to rationally understand what's going on in court today?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney and the work that he's done?
Yes.
Do you have any questions about the paperwork that you've read and signed?
No.
In this case, Mr. Manning has indicated that you've not been indicted by the grand jury. That means that you've been accused of a felony offense, but the grand jury has not met to review the evidence to determine if they believe there's enough evidence to proceed with your case. It's my understanding that you want to waive your right to that grand jury indictment and allow the state to prosecute you today by filing an information, which is a legal instrument that allows them to prosecute you with the court's permission. Do you understand that?
Yes.
And you understand that by waiving your right to a grand jury, it's not a right that you can later have restored to you. Meaning you can't say, I choose to waive it today, see how this case goes. And if it doesn't work out, then I'm going to ask for my case to go to the grand jury. You understand it doesn't work that way, correct?
Yes, sir.
All right. And do you have any questions about your waiver of indictment or waiver of the grand jury?
No.
All right. Has anyone threatened, forced, or pressured you to waive your right to an indictment?
No.
All right, Mr. Manning, you did counsel your client on what it means to waive her right to an indictment, and so do you believe that she's entering into that intentionally, knowingly, voluntarily?
Judge, I have explained that, and I do believe she's entering into that intentionally, knowingly, and voluntarily.
All right, the court does accept the defendant's waiver of indictment, finds that she's been admonished regarding her rights, that she has waived the same intentionally, knowingly, and voluntarily. All right, Ms. Connelly, it appears that you have been charged with the third-degree felony offense of possession of a controlled substance greater than 1 gram, less than 4 grams. The range of punishment for a third-degree felony is not less than 2 years in prison or more than 10 years in prison if you were to be convicted and sentenced. I see the plea agreement in your case is upon you pleading guilty, the state's recommending that the court consider the evidence but not convict you. They're asking the court to place you on deferred community supervision for a period of 5 years. you would be assessed a $1,000 fine, court cost of $290, and reimbursement fees of $535, and restitution of $180. Ms. Connelly, is that your understanding of the plea agreement?
Yes.
Ms. Connelly, do you understand that if the court approves this and places you on deferred community supervision, if you violate any of the terms and conditions which you have read and signed today, if you violate any of those, the prosecutors could file a motion, bring you back to court, and if they put on evidence that you violated any of your conditions, the court could do a number of things, including revoking your community supervision, convicting you of the offense, and sentencing you anywhere from that minimum 2 to the maximum 10 years in prison. Do you understand those things?
Yes.
And understanding all of that, you still wish to go forward?
Yes.
Mr. Manning, do you believe that she is entering into this plea agreement intentionally, knowingly, and voluntarily?
I do.
All right, Ms. Connelly, how do you plead to possession of a controlled substance in penalty group 1 or 1B greater than 1 grams, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No.
The court accepts the defendant's plea of guilt at this time. Mr. Manning, any objection to the evidence?
No objection is offered.
The evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest included, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement between the state and the defense. The court hereby defers a finding of guilt for Lindsay Marie Connelly on the 3rd-degree felony offense of possession of a controlled substance. The court places her on 5 years community supervision, orders her to pay a $1,000 fine, restitution of $180, court costs of $290, and reimbursement fees for $535. Ms. Connelly, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. After that, you'll meet with the probation officers.
Alrighty.
Who's next, Mr. Manning?
Judge, next ready on Mr. Ibara.
Cause number CR 25-88, CR 25-263, State versus Joshua Andrew Ibara. I believe we're here on the state's motion to revoke and also a docket call.
Yes, Judge. As with my announcement on Mr. Peck, I believe that a response from the state would impact the value of this case, as well as whether or not my client would assert his right to a hearing and or trial on these cases.
Said you wanted to hear from the state. Is that what you said?
Judge, in regards to what I announced with Mr. Peck, that I've become aware of a situation. I emailed the state, I believe it was yesterday, and I'm awaiting the response for materials that have not previously been provided regarding the officer in this situation.
Okay. Mr. Harwell, anything?
Your Honor, I don't have all the information that Mr. Manning is looking for on, but we'll work on keeping in communication with him.
All right, court will set each case on April 2nd. At 1:30. Who's next?
Judge, next ready on Mr. Brock George.
Clause number CR 25-268, State of Texas versus Brock Albert George. I believe we're set for pretrial and maybe status of competency evaluation?
Yes, Judge. I filed a competency evaluation after I was made aware of certain behaviors from Mr. George recently, by jail staff. I came and visited Mr. George last week. And discussed some of those things with him, as well as discuss some of the discovery. Judge, I think what we have here's a situation that on Mr. Brock's good days, or sorry, Mr. George's good days, he is competent. However, he does have some days where, for whatever reason, whether that's environmental, medication wise or otherwise, he just doesn't have good days. So at this time, I believe that Mr. George is competent, but I have requested a evaluation to be done, and I believe that. Did Dr. Ingram meet with you yet? No. Okay. I don't believe that Dr. Ingram has met with Mr. George at this point in time.
Is your client on mental health medications?
Yes, I'm taking medications.
Okay, which ones are you taking?
I know I'm taking lorazepam, and then Strattera, and is it Remeron?
Yes.
Mirtazapine.
Okay.
There's also the one in the morning. I don't know what it's called.
Okay, thank you, sir. All right, the court will grant the request for the competency evaluation.
Judge, and I think it's already been ordered. We're just waiting for Dr. Ingram.
Okay, well, we'll set this then to April 23rd.
Yes, Judge.
Pre-trial and status.
And Judge, I will say, in my conversation last week with Mr. George, we had a good conversation, and I was able to relay some information to the state. I think may be able to lead to resolution on the case once he speaks to the complaining witness in this case.
And then pending Mr. or Dr. Ingram's competency evaluation.
That's good, Judge.
All right, well, we'll set him for April 23rd. Thank you, Mr. George. Next.
Judge, ready on Mr. Baird.
Walter Lynn Baird, CR 25, 153 and 154. I believe Mr. Baird is set for a docket call.
Yes, Judge. Mr. Baird and I need to go over the state's revised offer. Well, I don't know if it's revised. I received an offer from the state this week that I have not communicated with Mr. Baird and discussed with him. Due to this week, I request an additional short setting to go over those and review, make final review of the discovery before we announce ready or whether we're going to accept an offer.
The offer, was it something significantly different than a previous offer?
Judge, I'd be lying if I told you I remembered at this point. All I know is that it was it is a time offer, and it was on CR 25-164 with CR 25-153 being taken into consideration.
Mr. Hartwell, did the state make a revised offer?
Your Honor, not so much a revised offer. State had emailed an offer some time ago. It got lost in the shuffle. I was able to find it and bring it back up and reissue that offer. So it's more a matter of we made one some time ago near the beginning of this case, Your Honor, and it just got lost in the shuffle.
And Judge, I believe that was before Mr. Baird and I had an opportunity excuse me, to review the discovery and for me to go to the DA's office to review the discovery. Now that I've done those things, that is kind of where we're at is circling back to that offer and discussing that in light of the discovery, both of the DA's office and the totality of their file.
Second.
I'm sorry, Your Honor, your mic cut out for a minute.
Court sets Mr. Mayor for final docket call on April 2nd. Who's next?
Judge, ready on Mr. Ponder.
William Lee Ponder, CR 25-185. Ponder self.
Judge, we've reached an agreement in this case, and I believe you should have the paperwork.
Swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Make sure you speak up loudly and clearly. Mr. Ponder, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you have any questions about the paperwork, that's your plea agreement that you've read over and signed?
No, sir.
Mr. Manning, do you believe Mr. Ponder would be competent to enter into an agreement? And if so, that he is doing it intentionally, knowingly, voluntarily, after understanding?
Yes, Judge.
All right, Mr. Ponder, it appears that you're charged with unlawful possession of firearm by a felon. It does carry a range of punishment of not less than 2 years or more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement case is upon you pleading guilty. The state is recommending that the court convict you of the offense, sentence you to 5 years confinement in prison, and they're also requesting the court to suspend the sentence and place you on 5 years of community supervision with a $1,000 fine, or cost of $290 and reimbursement fees of $585. And you would also be a weapon that was seized in this matter. Is that your understanding of the plea agreement?
Yes, sir.
All right, then understanding the plea agreement and the range of punishment, how do you plead to unlawful possession of firearm by a felon?
Guilty.
You're pleading guilty because you are in fact guilty of committing offense.
Yes, sir.
Anyone threatening or pressured you to plead guilty?
No, sir.
Accepts the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
Judge, we're having a hard time hearing you.
Any objection to the evidence?
None is offered, Judge.
All right, then the court does take judicial notice of the defendant's judicial confession. Anything further from the state, Mr. Harwell?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest in close, Judge.
All right, the court admits the evidence and is going to consider the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court follows the plea agreement. The court convicts the defendant, assesses punishment at 5 years confinement in prison. The court suspends the sentence, places the defendant on 5 years community supervision, orders him to pay a $1,000 fine, $290 tort cost, $585 reimbursement fees. Court hereby orders the forfeiture of the weapon seized in this matter. Mr. Ponder, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Have you step over and be fingerprinted. After that, you'll meet officers. Mr. Manny, if you want to bring up your next call.
Yes, Judge.
Is this Mr. Ogletree?
Yes, Judge.
All right, this is cause number CR 24-307, State versus Philip Andrew Ogletree. And is Mr. Ogletree going to be doing it today?
Judge, I'm having a hard time. Our volume's all the way up and we hear Mr. Hartwell very, very well, but we're not getting your.
All right, give me a second. Let me test it out. Mic test, mic test.
Judge, that was much better.
All right, sorry about that. All right, this is cause number CR 24-307, State versus Philip Andrew Ogletree. Is Mr. Ogletree doing a plea today?
Yes, he is, Judge.
All right, let me find his paperwork real quick. I don't see his paperwork on my end. Has it been routed to someone else?
Judge, Ms. Burns says she signed it.
Let me see if it was done earlier. Was that recently?
Judge,
It was done at 1:48.
148.
148, okay. That could be why. Yeah, there it is. All right, Mr. Hartwell, Mr. Manning, looking over this plea, it looks like the proposed plea is for him to plead guilty to improper contact with a victim while confined, with the recommendation being 10 years in prison, probated for 5 years with a lifetime protective order. It's my recollection that Mr. Ogletree has been on probation in this court and was not successful. Is my recollection correct?
I'm unsure as to Mr. Ogletree's prior success. This offer was given to me by the elected DA, Ms. Curry, and it came directly from her based on conversations she had had with law enforcement regarding this case.
Mr. Hartwell?
Your Honor, I can take a quick look. I too am unfamiliar with Mr. Ogletree's history with this court. A lot of it predates my employment here. But I can take a quick look and see.
Yeah, let's do that. The court's gonna stand in recess for about 5 or 10 minutes.
Your Honor. It says we can't start our video because you've disabled it. We know we don't look very good, but
Judge, it's saying it's this, oh, okay.
thank you.
Okay, all right, we are back on record, cause number CR 24-307, State versus Philip Andrew Ogletree. All right, the court refreshed its recollection. I believe that Mr. Ogletree was on felony probation when I was acting as the criminal district attorney, and that's probably what I remember. And then it occurred to me that this court sentenced him in 2021, I believe, for sexual assault of a child. And it appears that this offense arose out of that offense when he was incarcerated in the Texas Department of Criminal Justice.
That's correct, Judge.
So looking over what the proposed plea agreement is for probation, the court rejects that plea agreement. So Mr. Ogletree can come up with another plea agreement, or he can request a trial. If he wants probation, he'll need to get it from the jury.
Yes, Judge. Obviously, I guess I'm unsure as to, Judge, I believe his last probation was in 2016. It was a state jail deferred probation. I don't show, based on my communication with the state or with the probation department, he's been on any other supervision other than that probation in 2016. 2011. I'm sorry, 2011 through 2016.
Well, he's been on TDC supervision, and when he was on TDC supervision, he committed a new offense. So let me be frank. I'm not going to approve a probation for Mr. Ogletree for contacting the victim of the case that I sent him to prison on. No way, no how. If he wants probation, he can go get it from the jury. I'm not going to grant that.
Yes, Judge. Okay. Well, in that case, then we request to be reset for docket call in this case.
All right. Court will grant Mr. Ogletree an additional, well, I think we were on pretrial, so we'll set it for docket call. Is April 2nd enough time, or do you need more time, Mr. Manning?
Judge, I would have to check with my client, but I believe that we have a potential defense that if we get confirmation from the victim from the case that he was sent down on, I believe there's a defense to this offense that would, if it goes to trial, would negate his guilt in this case. So my guess is we'll be heading straight to trial after this next setting.
All right, court sets Mr. Ogletree then for docket call April 2nd at 1:30. All right, Ms. Abraham, does that conclude our afternoon docket? All right, if there is nothing further, then we are adjourned on the criminal docket. Thank you, gentlemen. Thank you, Ms. Patty.
Thank you.
And whoever helped at the jail staff to get us going on our Zoom, tell them I appreciate their help very much.
We will.
And I appreciate y'all's patience working through that.